Nonpartisan. That's the word on the ballot. That's the word on the press releases. That's the word they use when they want you to believe this is a quiet, little administrative matter that doesn't really touch your life. It does. Wisconsin holds a Supreme Court election on April 7th, and today we're going to look at it the way we look at everything here. Not as a team sport, not as an outraged delivery system, but through a framework that actually helps you think. Because if you believe that legitimate government derives its power from the consent of the governed, then you need to understand what this election actually decides. The Wisconsin Supreme Court is technically nonpartisan. No party label on the ballot. That's by design. The premise is that judges interpret law. They don't make it. That the courthouse stands apart from the legislature and the executive for good reason. The framers of our constitutional system called it the separation of powers, the idea being that no single branch should hold all the authority, that each branch answers to a different constituency at a different time with different accountability. Courts answer to the Constitution, and in a healthy democracy, the Constitution ultimately reflects the will of the people through a transparent, consensual process of interpretation. That's the theory, anyway. Here's what Wisconsin Supreme Court actually decides. In the last several years alone, the court has ruled on abortion access, redistricting maps, collective bargaining rights, environmental regulation, voting procedures, the governor's emergency powers, and whether the state's top elections official could even keep her job. That's not administrative. That is governance. And the winner of Tuesday's election, either Judge Chris Taylor or Judge Maria Lazar, will sit on that court for 10 years. They will rule on cases that include the 2028 presidential election. Still sound nonpartisan? This is exactly the kind of question we take up in the consent brief. We use the term consent as policy here at Ethos Trek as a framework for thinking, not as a slogan. The question is simple. When power is exercised over people, did those people meaningfully agree to the terms? Voting is the most fundamental act of consent in a democracy. You choose your representatives. You authorize, through your vote, the policies they pursue. That consent is only real if the system is designed to honor it. If your ballot counts, if districts reflect actual voters, if the rules don't change after the fact to produce a predetermined result. The Wisconsin Supreme Court has become the place where those consent questions get resolved. Who can vote? How? Under what conditions? Whose ballot survives a challenge? Whose doesn't? That means the people on that court are, in a very real sense, gatekeepers of consent itself. So let's look at the record. We're going to spend more time on Lazar's record here, not because the other candidate doesn't have one, but because her rulings, Lazar's rulings, directly engage the consent question. Let's let the record speak. Judge Maria Lazar is the conservative candidate. She's an appellate judge from Waukesha County with a long legal career, and her record is documented. On voting access, before becoming a judge, Lazar worked as an assistant attorney general under Republican leadership, where she defended Wisconsin's voter ID law and the Republican-drawn redistricting maps that critics described as among the most aggressive gerrymanders in the country. As an appellate judge, she ruled that voters with disabilities cannot receive absentee ballots electronically, a restriction that does not apply to overseas or military voters. She also joined a panel that reached the opposite conclusion from another appellate court in a case involving access to voter guardianship records, a case brought by a conservative group seeking to challenge the eligibility of voters. The Wisconsin Supreme Court will decide that case. On the environment and public health, in a ruling with direct implications for Wisconsin communities, Lazar ruled that PFAS, perfluoroalkyl substances, commonly called forever chemicals, cannot be regulated under Wisconsin's existing spills law, finding that the state's DNR's enforcement amounted to unlawfully adopted rules. PFAS don't break down, not in the environment, not in the body. They're linked to cancer, immune system disruption, and developmental harm in children. The ruling left communities without a regulatory tool the state had used for decades. On constitutional interpretation and federal policy. When asked about President Trump's executive order asserting that the 14th Amendment does not guarantee birthright citizenship for children born to undocumented parents, Lazar did not affirm the settled constitutional interpretation. She said birthright citizenship is not necessarily absolute, and that Congress and the President can interpret the scope of citizenship rights. The 14th Amendment says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. Courts have interpreted this as a near absolute guarantee since 1898. That position departs from how courts have interpreted that amendment for more than a century. On reproductive rights, Lazar has said she would not necessarily have joined the majority in the Wisconsin Supreme Court's decision striking down the state's 1849 abortion ban. She has called the federal Dobbs decision, which eliminated the federal constitutional right to abortion, quote, very wise, unquote. On the institutional network, Lazar is a member of and has spoken before the Federalist Society 3 times. Her 2022 campaign received $250,000 in supportive spending from, quote, Fair Courts America, unquote, an out-of-state dark money group she did not disavow. Fair Courts America is part of a broader judicial influence network tied to Leonard Leo, the architect of the conservative legal movement responsible for shaping the current United States Supreme Court. She did not raise significant funds from Wisconsin individual donors, and she was outraised by her opponent nearly 10-1. On the religion question, at a March 2026 campaign event in Germantown, Lazar was photographed praying with supporters. Her campaign has released a formal position paper on religious freedom, framing the courts as a bulwark for religious expression in the public square. Her candidacy announcement said she entered the race after, and this is a quote, lots of prayer. That's a personal matter for her. What's not personal is that a judge who campaigns on religious identity in a nonpartisan judicial race is signaling something about which values they bring to the bench. Nonpartisan is the word on the ballot, but it is not what this race is. The consent question. Here's the thing about consent as a framework. It doesn't tell you how to vote. That's not its job. What it does is give you a lens. Ask yourself, Which vision of this court preserves the mechanisms by which I can meaningfully participate in my own governance? Which candidate's records reflects a commitment to keeping those mechanisms intact or restricting them? If a justice limits who can vote, narrows how ballots are counted, rules that environmental regulators can't protect your groundwater, sides with the constitutional interpretation preferred by the current White House, and is positioned by national dark money networks before Wisconsin voters even know her name, that is not a neutral act. That is governance, and governance without consent has a name. That's one approach to these questions. Chris Taylor represents a more conventional one. Chris Taylor is the other candidate. Her record is closer to what you'd expect from a judge operating within existing frameworks. As a legislator, she supported PFAS protections. As an appellate judge, she ruled in favor of broader absentee ballot access. She's backed by labor, environmental, and civic organizations. If you want to examine her record, links are in the show notes. This is not a horse race. I'm not here to tell you who wins. I'm here to tell you what the choice actually is, and to make sure that when you walk into that polling place, you've thought about it clearly. Not every race presents two equally contrasting records. This one doesn't. Here are your 3 things to do before April 7th. 1. Confirm your polling place. Wisconsin voters can look up their location at myvote.wi.gov. Early in-person voting is open through Friday, April 4th. 2. Look at both candidates. Full records. The Wisconsin Elections Commission and Ballotpedia have nonpartisan summaries. The Brennan Center's Buying Time Wisconsin tracker shows who's spending money on ads and where it's coming from. 3. Share this episode with one person who said this race doesn't matter. Because in 2028, it will be this court that decides what counts as a legal vote in Wisconsin. That matters. These are the candidates: Judge Chris Taylor or Judge Maria Lazar. Wisconsin, please remember to vote April 7th. I'm Sarah. This is Ethos Trek. We'll see you Thursday for our long-form series installment. The link to our full Wisconsin Supreme Court research brief is in the show notes below.